Okay, welcome everyone to this meeting.
Who better mute out? Is it star 7?
Yeah, star 6. Star 6 mute you and unmute you. So welcome everyone again to this Money Banking and Trust by Moving Titles and Commerce this December 22nd. And this is the first meeting on Tuesday. And I'll probably continue on a Tuesday meeting. I might change the time maybe a little bit earlier, I don't know. But the topic for tonight is why we're not getting a remedy. And through studying this trust material, I've come across the solution to why we're not getting a remedy. So if anybody's not speaking, just we're going on the Q&A mode here later on. So could you press star 6 to mute yourself? Thank you. I've been talking about on the Saturday show there, going over section 4 in the Gilbert's Law book, the book on trust. And one thing I've noticed is the downloads that we've had of the copies that somebody copied. If you're following that, apparently there's some missing pieces. So I don't know if that was done intentionally or for what reason. It might be for disinformation. I'm not sure. But the best thing to do is make sure you have the book. So I would get the book, Gilbert's Law Summary, the book on trust, by Edward C. Halbach Jr., because the downloads, for some reason, there are some missing sections in there and missing pages, so it does not follow with what I've got. You might not be able to follow along if you just use that as a sole source, so I recommend that you get the book. I mean, it's only less than $30, so. So Chapter 4 was the transfer of beneficiaries' interests, and that was starting on page 127, section 441, talking about the alienability of beneficiaries' interests. And I liken that 441 section and 442 section to the except for value on a debtor-creditor relationship side, but this is where that comports to the trust side. Although this is not except for value, return for value, it's got to do with the trust, where it's talking about the transferee's rights under Section 442. So a beneficiary can assign, that's on a UCC 3, only such interest in the trust as she has. And the transfer is not a transfer of the trust resident itself, but only of an equitable interest therein. And whatever conditions or limitations, now that's what is liens, what are liens, conditions or limitations. Whatever conditions or limitations attached to the beneficiary's interest prior to the assignment apply against the assignee or the transferee. I liken that to the except for value. Now we're leading up into the next section under B on page 131, which is talking about the restraints on alienation. And here's where I mentioned on the last show on Saturday that is probably the biggest bingo in the book. And that bingo is talking about a spendthrift trust, and that's section 460. Where it talks about a spendthrift trust is one in which by statute, it says C supra section 443, so by statute or more often by virtue of the terms of the trust, the beneficiary is unable voluntarily or involuntarily to transfer his interest in the trust. In other words, he cannot sell or give away his right to future income or capital, and his creditors are unable to collect or attach such rights. And this type of trust is usually created to provide an interest for the beneficiary that will be secure against his own improvidence. And I had a note here that you could see the W-8 bend form that we've gone over under Part 3, which is the notional principal contracts on line 11. So big bingo here is to think of the spendthrift trust as being something else, not a spendthrift trust. So I'm going to read it again and plug in some different information. So the spendthrift trust is one in which by statute, or more often by virtue of terms of the trust, and this is the bingo, the terms of the trust is really the Declaration of Independence. So that's what we're talking about here. So the terms of the trust, the beneficiary is unable voluntarily or involuntarily to transfer his interest in the trust. In other words, he cannot sell or give away his right to future income or capital, and his creditors are unable to collect or attach such rights. And this type of trust, in other words, the Declaration of Independence, is usually created to provide an interest for the beneficiary that will secure against his own improvidence. So our founding fathers have written the Declaration of Independence, and it says in there that we have unalienable rights. And unalienable in Black's law means you cannot transfer it. So, in effect, that is a spendthrift trust. And just as it says here under this spendthrift trust section, the creditors are unable to collect or attach such rights. That's exactly what it says in the Declaration of Independence. They're unalienable rights. And this type of trust is usually created to provide an interest for the beneficiary that will secure against his own improvidence. In other words, if you did something wrong, the trust was designed that it didn't make any difference what you did. Your interest was still protected, and you couldn't give it away, and it couldn't be attached. Now that's under 1776 law form. So that was the big bingo I revealed that one Saturday. Now going on a little farther in this section, I didn't quite read far enough ahead until I got in there and I started thinking, okay, this other stuff applies also. Now I jumped to page 134, which is section 475, where it talks about creditors' rights and actions. So if there is a valid spendthrift provision, in effect, creditors are generally barred from reaching, that is, attaching, and selling or taking the beneficiary's interest in the trust. Then I jumped ahead a little farther. Page 138, section 490. Let's talk about discretionary trust. Discretionary trust. So a discretionary trust is one in which the trustee, now that would be the trustee of, say, the U.S. bankruptcy, Secretary of Treasury. So a discretionary trust is one in which the trustee is given discretion to make or apply with, let me start over again here. The trustee is given the discretion to make or apply or withhold distributions of income or principal, or both, to or for one or more of the beneficiaries, whether or not it provides standards for the trustee's guidance. Now I jump down to page 139, section 498, next page, talking about protective trusts. A protective trust has long been used in England and is increasingly used in American jurisdictions. See section 493. A protective trust usually is an ordinary trust that pays out its income regularly, but which upon an attempted voluntary or involuntary alienation of the beneficiary's interest becomes a discretionary trust. It says, continuing on, it says, sometimes a broad one to apply the income for the benefit of any or all of the group that includes the original beneficiary. And to give an example on the next page, page 140, it says the settlor to trustee and trust pay income to the child for life. But if child ever becomes insolvent, or bankrupt in other words, or creditors attempt to reach his interest in the trust, or if the child attempts to assign his interest, then to pay such amounts as trustee deems appropriate to or for the benefit of the child. And then down in Section A, the rationale here is, a protective trust may be intended to reach a result somewhat comparable to, and in fact, more secure than, the result of a spendthrift trust. But it is logically less objectionable in that the beneficiary can be sure of receiving substantial trust benefits as long as he keeps his debts paid. On the other hand, these trusts are subject to the criticism that they accomplish indirectly what they could not do directly in some states. It says the Bankruptcy Code, Chapter 11, USC, Section 541C1B, no longer accepts the intended result of protective trusts. So now, let's put this in a better perspective picture we can understand today. 1776, your founding fathers created a so-called trust, aka a spendthrift trust, which had protections on it that the unalienable rights couldn't be given away or couldn't be attached, couldn't be leaned up. But they still owed a debt from the war. And some creditors came along, the people who the debt was owed to, and they tried to foreclose or lien up the beneficiary's interest or the beneficiary's assets. So a protective trust came into play, which was used in England, and it was used more and more in American jurisdictions. So the protective trust came into effect upon an attempted voluntary or an involuntary alienation of the beneficiary's interests. And it becomes a discretionary trust. So the definition of the discretionary trust was, again, is one in which the trustee is given discretion to make or apply or withhold distributions of income or principal or both to or for one or more of the beneficiaries. The beneficiaries are we the people. Whether or not the instrument provides standards for the trustee's guidance, and that would be the Declaration of Independence. There are no provisions in the Declaration of Independence that say anything very specific. So that leaves a lot of room for construement. These founding fathers knew that they didn't want to give away the rights, so they designed it in there, and they said that the rights for the beneficiary were unalienable. But when the creditors came in to see if they could get paid for the debt that was owed, the protective trust came in, but the protective trust also went into a discretionary trust, and the beneficiaries can't get access to the income because it's per the discretion of the trustee. This is an expansion on the first bingo of the Declaration of Independence. Building upon that, make it even a bigger bingo. Because that tells me the reason why we're not getting a remedy is because it's per the discretion of the trustee. And that makes sense. Because I don't care what remedy you use, whether you use a commercial process or some other litigation method and some things, it doesn't seem to be working in any consistency at all. Only a small amount of people get some kind of remedy. But yet that's like the dog bone that keeps us on the scent trail so that we keep on pursuing that trail, or liken it to the bull who's being led around by the nose ring, walking around the mountain on a path that was really the wrong path, but yet we think we can tweak our silver bullet paperwork a little bit better and put a little better paperwork or say a few more magic words, and we might have a better success. But here all along, it's always been per the discretion of the trustee, whether or not you had a remedy or not. Because there was a discretionary trust formed from this protective trust, and it was really all for your benefit, so that the creditors could never touch the beneficiary interests, couldn't put a lien on them, and couldn't gain access to them. It was all done for good intentions. Now, I'm going to go back to that section on page 140. where it's talking about that rationale again on A, where the protective trust may be intended to reach a result somewhat comparable to, and in fact more secure than, the result of a spendthrift trust. Remember, spendthrift trust is your Declaration of Independence. But it is logically less objectionable. And why? In that the beneficiary can be sure of receiving substantial trust benefits only as long as he pays his debts. The key to the whole problem is you got to pay your debts. What debt are we talking about? The original war debt. The debt that's been keeping us in bankruptcy all this time. And that was the reason why we had to go to a trust to protect the financial assets of we the people, which is the country, really. The people own everything. To protect the assets from the creditors, the debts that we owed during the war, 1776. That original debt is still owed, and that has been kept us in bankruptcy all this time. If we go back and we pay the original debt, that will free up and get you access to the total assets of the trust. If we all pay our fair portion of the debt, we will gain access to the trust. Because now the trustee has no discretionary power because you're not insolvent. So, anybody have any questions so far? Press star 6 if you have a question.
We recording this question.
Yes.
Yeah, I got a question.
Yes, who is this?
This is Darren.
Darren? Okay, go ahead.
Well, the one thing you got to understand, especially in regards to the war debt, which there's been two institutions that have never been audited, and that is, of course, the Federal Reserve as well as the Department of Defense, because they have not been audited, so we don't know what our proportionate share is. So in technicality, we are still paying for the Spanish-American War.
Okay, I really don't care which war it was or whatever debt it was. I don't really care how much the debt was, because I have access to unlimited funds, and I am capable of paying any amount the debt is. And I would just give them instructions to pay the debt, my fair share, whatever it is. Let me know what the amount is, get it out of the account, and disperse the funds.
And who would that be to?
Well, I would imagine that the master record keeper is the IRS with their IMF file. They are the master accountants of everything that the United States owes. I imagine they're the ones that know the figures.
Or would it come from the Department of Defense?
Well, I suppose it might, but, the accountants are the IRS. They're the bean counters.
That's true.
Christian did a process with the commissioner of the IRS and gave him instructions after we claimed the Declaration of Independence being our master trust, and then gave him instructions after we've established our claiming of the trust and proving of the trust, which gives us standing to make a claim as beneficiary, and then I would give him instructions to whoever is necessary to, if it's not him or maybe somebody else we find out maybe later on, give the instructions to pay our fair share of the debt. And once that debt is paid, now we have access to the trust without a discretion for the trustee. As long as we keep things on a private side, we have the ability to issue as much private credit and generate as much interest on the public side to pay any consumption of goods and services that we need for the real money.
Christian, how do you suggest we pay it? How do we, with what? How do we go about doing that?
Well, you're going to issue a money order for the amount. Whatever the amount is, that's your fair share. And it's a non-negotiable private credit. Non-negotiable debt instrument. Private credit. And it has to be non-negotiable. That way it's strictly private.
Wouldn't you need an invoice first?
Well, I could just give them a blank check and say, fill in the amounts and let me know what the receipt is. I think if I make the offer for pay the fair share of the debt, that relieves me of my obligation. Just fill in the amount. Anybody else have a question?
This is Daryl. I have a question.
Go ahead, Daryl.
Well, I agree with what you're saying as far as the war debts. And I know that those have been passed down through generation and generation. But what we currently is a situation where we have a lot of theft and unconstitutional and unapproved by the people expenditures. And I don't see why we should be responsible for those. I think we should prosecute these people for what they've done.
Yes, if we first prove that they've broken any kind of laws. Now, if you look at it from a trust perspective, they've really been working for us. Now, there may be a few of them out there that have been trying to, gain total access control of everything. Yeah. But, basically, we the people have gone to sleep, and I can't blame them directly. I have to blame myself. Because really, I had the first move, but I didn't make the move, so they had to do something with it. And naturally, if you're going to tell the fox to guard the chicken house, you're going to come up with some chickens missing. Mm-hmm. I agree with those that are guilty of some kind of impropriety should be punished, but that's not the point. The whole point is that we need to pay the debt because that's what a creditor would do. And then we'll argue about the fine hairs later on. But when we pay the debt, we gain access to the whole ball of wax. We gain access to the account, and that's what we all want, don't we?
Sure. But, I've been reading some of the congressional record from 1932 and 1933, and the chairman of the House Banking Committee gave a very scathing indictment against the Federal Reserve and what they have done as far as stealing an ungodly amount of money and stealing gold and silver.
We're getting off topic. It's not, I want to punish those wrongdoers. No, we want to get, what is the first step? The first step is we want to gain access to the funds. We need to get a whole lot more people involved in this and get them educated and get them on point before we have any kind of capability of doing government, because we don't know how to do government. We can't just do government by turning it over to somebody else and sending them up to D.C. and telling them, fix my problem. If you don't know what your problem is, how are you going to tell them to fix your problem? All right.
Well, I don't know if you're aware of
an argument on this topic. Let's keep it more on point. Let's talk about gaining access.
I have a question.
Yes, go ahead. What's your name?
Was someone else asking at the same time? My name's Kenny.
Announce yourself,
Kenny.
please.
My name's Kenny. Can you guys hear me?
Yes, I can hear you.
Okay. Are you fielding all types of questions with regard to NTT?
Yeah, within the limits of what we're talking about on scope tonight, yeah.
Okay, well, my questions were going to be with regard to the SS5 form itself, and I had a couple of UCC-related questions.
Go ahead.
So can I go ahead with that? Okay. On the NSS-5 form that you've talked about as far as establishing status as grantor, you spoke of line 5 where you check other, and I'm assuming you're talking about just writing American up there next to that. Is that what you meant by that?
Yeah, that's what I did in the past, yeah.
Okay. And then with regard to box number 18, where it says your relationship to the person in item 1 is, I've been toying with that, and I'm not sure if it would be self or if it would be other.
Yeah, now when I did that American up there and checked that block, what we did is we did the 521 form with that and totally got out of Social Security. Now, if I was going to redo that form again, I would probably maybe not check that, because they're looking at that form as being all fiction, and that's the straw man. So I would maybe check under this condition, check, because the straw man is a citizen.
Can I interrupt for a second? I did not hear what you said. And someone who evidently still does not understand the call protocol has not muted themselves out and keeps making noises.
If you're not speaking, could you press *6? Or you mute out.
Thank you. There it goes again. Didn't hear that last thing you said, Christian.
Yeah, we did when I checked the other block and I put American up there, we did a 521 form to totally get out of Social Security. And that's what we did under that circumstance. But under this circumstance, if I was going to redo it again, I would probably check, since this is all a fiction form anyway, the United States citizen, who is the straw man.
Mm-hmm.
And then when it comes down to the bottom part to the right there, where you're going to your association or your capacities, I would either put in there authorized representative, or there's where you might put in grantor or beneficiary.
Yeah, that makes sense. Okay, then with regard to setting up your status as beneficiary, were you suggesting that after you got, in this instance, I'm talking about using this form to get another card? And so the question is, were you suggesting signing the card itself by beneficiary, and then that card itself became part of your setting up your status as beneficiary? Is that what you meant?
Yes, because when I got the card back, I'm going to sign up by beneficiary, and then I'm going to keep the original card, but yet generate copies of it and send the copies out to parties that I need to notify of the record that I am the beneficiary. So I'm using the copies as the evidence.
Right. Now, you suggested, you've talked a bunch about UCC1s and UCC3s. I want to make sure that I'm wrapping my head around this. My understanding of UCC1s and 3s is a 1, of course, is the first filing, and then if you are using that, continuing with that same 1, then you're just doing 3s as amendments to the original 1. Is that the way you're suggesting doing this, or you suggest filing new 1s each time you're doing something?
Yeah, I'm using the UCC1 just to claim title. I'm using a UCC3 to assign the title or move the title.
Right, but if you already have a UCC1 in place, you already have a financing statement in place, in order to add anything to that collateral box any point after that, you would only need to do a 3, correct?
After you claim the title, yes.
So if you already have a UCC1 in place, and you use a 3 to amend that 1 in claiming title, then wouldn't you later on assign the title or do anything else you want to do just by continuing to do 3s, which amends it?
Titles I need to claim at different times, so it's going to be going on my 1. I'll be making an amendment to my 1. So if
exactly.
I have an original filing of a number 1, and then I have another title I want to claim, I'm going to do an amendment to that, put that additional title that I claim on that 1, then do a 3 to move it.
Okay, so let me phrase the question this way: if someone already has a 1 in place, and they want to claim a title, like say for instance you're setting yourself up as you're setting up your status as grantor beneficiary by doing some of the things we spoke of previously, would you need to file another one, or could you not just continue to use the same one that you already have set up and just do a 3?
Just I get an additional title that pertains to that, say like a court case, and I turn that into a title, then I have to claim that title. I'm going to claim it on the UCC1.
Right, but you make that claim by filing the 3, which amends the 1, correct?
So the 3, I'm going to use it to move also.
Okay, I'm still not understanding that one, because my understanding is initially you file a 1, and then if you any amendments you make for that 1, you use a UCC 3 to do so. But I guess what I'm trying to figure out is, if you're working with...
Claim the title.
I'm sorry, I was talking at the same time, and no one would have heard that. Go ahead.
Make an amendment to the 1, claiming the additional new title, and then use a UCC 3 to assign it to whoever party you want to give the liability to.
Right, but once again, maybe I'm not asking this question clearly. I guess the question is, if you already have a 1 in place, could you not just do a 3 to claim title and then do another 3 to assign title or do anything else you wanted to do?
Yeah, because all you're using those forms for is just a record of that you claimed the title or moved the title.
Right, so you wouldn't need to file another... If I'm trying to set up status as a grantor beneficiary, and I already have a 1 in place, I wouldn't need to file another 1. I could just do a 3 each time, which amends the original 1.
It's mixed up with the purpose of how we're using the trust, the UCC under trust.
I have something to add for me, Christian.
Yeah, one other point first. There's an additional block down, I forget what line it is, that it actually has where you set the nomenclature of the whole form by the Baylor-Bailey filing or by a lease or leasee filing. There's a certain blocks that you can check there. The last block on the right is a non-UCC filing. If you check that block, you're not under UCC, debtor, creditor, or anything else like that. It's just a record filing. So go ahead.
With regard to doing a UCC3 assignment, be leery on doing that, depending upon what you're trying to accomplish. Because when you do a UCC3 assignment, partial or full, if you tie that to your original UCC filing, a lot of times when you do that partial assignment, it hides the rest of your UCC filing. And they'll take that UCC3 assignment as not a transmitted utility. So let's just say 3 years or 5 years down the road when it terminates, if you attach that to your main UCC filing, when it terminates, you've terminated your UCC filing.
Well, that would only be true if you didn't do it if you did it as anything other than in addition to the collateral, correct?
Say that again?
Well, if you did it as an addition to the collateral, to what's already there, because there's some choices on that. I'm not looking at that form now, but I recall there's some choices there where you can, when you're doing a 3, you can actually replace everything that's already been done, or you can add to it. You can change it. So if you were doing it as an addition to what you already had in a collateral box, wouldn't it still be valid?
Yeah, it would still be valid, but about the point that I'm making, because you brought up about the assignment. So if you get UCC3 to amend your original UCC1 to update it, so to speak, right? And if you're going to do something with the transference of a negotiable instrument by way of doing an assignment, if you piggyback off of that original filing, even though you have amended it, when that partial assignment expires, you have just terminated your trust, your original filing. So if you're going to do something where you're going to, once you have amended your UCC1 filing by using UCC3, and in the process of tendering a debt of some sort where now you want to reference your UCC, your original filing, but do it on a separate UCC1. So once you have did the assignment of the new one, whether it be partial or full, it will not do anything to your original filing.
Oh, so that gets back to what we were talking about earlier then, as far as filing a new UCC1 in the case where a person or a man or woman might already have one in place. Based on what Christian also said, it sounds like if you're attempting to set up your status as grantor beneficiary, you probably would be best filing an entirely new UCC1, working with that and checking a non-UCC filing on the form. The other question that comes up for me would be, would you check any of the other things on the form? Example like Baylor, Bailey, transmitting utility, and the other stuff. Would you leave all that stuff blank? And then I'll defer to the next caller.
Well, I would use the non-UCC filing, which is going to indicate everything I'm doing is non-negotiable. Non-negotiable is private, and that's where I really want to keep everything as private.
So if you were to check anything else, that would put it into a non-private status, then, wouldn't it?
Right.
If you check, for example, Baylor Bailey relationship, or if you check transmitting utility, that would be public. And yeah. I'm sorry. Go ahead.
Yeah, I'm saying it would probably put it back into the public again. You've got some other kind of public relationship. Baylor Bailey is not a trust, and a trust is private.
Was that Lila that was speaking just a minute ago?
Yes.
Okay, so Lila, I guess you're maybe suggesting too that if you're making assignments and releases of negotiable instruments, each one of those negotiable instruments might want to be on its own UCC1 and not related to other stuff like security agreements.
No question. Yeah, they'd be all by themselves.
That what you got?
I apologize. Go ahead.
Go ahead.
Yeah, but that's what you're always going to do when you are using negotiable instruments. That is a separate transaction. So just because, let's say, for instance, you're recording bond number 01, let's just say 1011 through, as I've done with my closed checking account. I've taken the numbers off my closed checking account, and I've used the next check that I have all the way to the end. So that's all my original UCC files. If I'm going to do a negotiable instrument, be it a bond, a promissory note, whatever the case may be, or even one of my checks out of my canceled checking account, that is going to go on a separate UCC filing. In the body up on the first page, I'm going to reference where the original filing number is to which these negotiable instruments were recorded on. Now we're going to take it, finish the collateral box as to what I'm using it for, whom I'm using it for, and I'm going to file that one. 30 days later is when I would do the assignment. And I'm going to do either a partial or a full. Now keep in mind, different schools of thought. Once you do that assignment, you're also going to record whether you have done an A, 1099A, B, INT, or C of that negotiable instrument. Because you just created a taxable event, and you cannot trust your brother to do what he's supposed to do. That's why we get charged with willful failure to file. That's the person that doesn't want to record it. But I'm not going to dwell all into that because this, I want a Christian that's doing what he's doing.
Yeah, thanks for that. Thanks, Christian.
Okay. So, sure, when you're done speaking, if you press *6, mute back out. Anybody else have a question?
Yeah, Christian, this is Danny in Texas.
Go ahead.
Getting back to paying the debt and the fund, I've got kind of a question and a statement. If funds are still there, that tells me that they haven't taken the funds. They've used them, but they have not taken them, or otherwise we wouldn't be able to access funds in any way. So what's your comment on that?
We had some noise problem here. Could you repeat the last part again?
Yeah, if the funds are there to be taken, that means that they haven't taken the funds, so they're still there.
Right. You know, all of this, all these funds that they supposedly took from us, or rather we volunteered them into them, they've held in trust. They're being held in trust, and they still are in trust. So the funds still are there. We just have to gain access to the trust. And we gain access to the trust by paying the debt.
Thank you. That was my question.
Christian, this is Kim Marie. Can you hear me?
Dan?
I've been having technical difficulties all night, so can you hear me?
Yes, go ahead.
Okay, I have a couple things that I wanted to mention. I really like the direction you're going. I've been studying the IRS forms and the publications, and I want to mention something. When I started studying the 720 excise tax form instructions publication, there's a manual, but there's also the publication that goes into estates and taxes. What I'm learning is that they're giving you ways to go back as far as you're willing to file as a reporting agent. So at the moment, I'm going back as far as when my Christian birth certificate name was dissolved by the marriage in 1996. Because I got married and there was a merger and acquisition with that title. So I'm giving myself the ability to go all the way back to 96. And when I look at these forms, they're giving us the ability and opportunity to take responsibility for even the oil spills back in the day. And they show us how to calculate it. So what you're leading to and alluding to as far as getting us access to this account is when I see the word trust, I see the word credit.
Right, that's credit. So like the example on the oil spill, that might be a public debt, but it's not a private debt. Because really, under debtor-creditor, we have nothing but fiction currency, which has no value, really. That's the reason why we can't complete a contract. And that's why trust had to come in and fill the void anyway. But the point is, how can we create a lien to pay a lien, and don't we just double lien everything? Create double debt? But really, what is the debt? It's all fiction. It's all make-believe. It doesn't really exist. In Oz,
So here's one of the things that I'm seeing with the UCC document is the trust is the secured party. The trust is the vault that has all of the money from the trust that they created from us. So a lot of these UCCs are filed in such a way where we're trying to claim a living man in a commercial water where a living man isn't recognized. We're all entities. And all we are
apples and oranges here, because now you're talking about, UCC and debtor-creditor, but really we want to stick solely in private. We want to talk about special deposits, because all the gold and the assets are held in special deposits, and they cannot be commingled. Or if they are, we've got to breach of trust, breach of fiduciary duty. And I don't think commingle the funds, but the funds are still there held in trust, whether they're like in one of the, but yet the accounting system is still set up that they know what the debts are and they know what the assets are, except nobody's given instructions to do any kind of set off or discharge.
So if we're discharging for others, let's say a group of others, are we
are we not expressing the trust in using our private side to assist those others in their liabilities and their encumbrances?
Yes, we could probably do that. Let's see if that's possible.
Okay. So the second thing I wanted to say about the UCC, I really like what you're saying about having it be called a non-UCC, which you're saying is declaring a private usage of financial assets, in a sense.
Yeah, we're going to be doing nothing more than with non-negotiable instruments. If we start talking about negotiable instruments, you're in public. Non-negotiable is private. Negotiable, under the Bank Officers Handbook of Commercial Banking Law, under Section 19.02, under the Certificates of Deposit. And let me read you that. It says Certificates of Deposit. CDs are instruments issued by the bank specifying that a certain sum of money has been deposited. These certificates may be either negotiable, that's non-negotiable, that's private. And when non-negotiable, the bank simply contracts to return the amount to the depositor plus any contracted for interest. That's non-negotiable. So if the certificate is negotiable, the bank agrees to pay the depositor or any person whom the depositor shall order or the bearer of the certificate. When the CD is when the CD is negotiable CD, the debt of the bank is to the legal holder of the certificate and not to the original depositor.
Oh, okay. So let me give you an example of what I've actually attempted to do, which is create Chase Bank as a secured party to be an offer I've given them to be power appointment to be a third party or a fiduciary on these bonds that I have that are connected to my indemnity bond.
Okay, right now, from everything that you said so far, you're telling me that what you create is nothing more than a bunch of debt. You're on the public side. And none of that stuff is going to pay anything.
Yeah, got it.
Because we've done everything wrong.
With the bank.
You guys done it wrong, I've done it wrong. Because all the stuff we put into the treasury, we didn't put it in under special deposit. We just did a UCC presentation.
Right. Got it.
We never made a special deposit. Not only that, we didn't even put it on the right side of the treasury. We did nothing right.
Right.
There's two sides of the treasury. Everything we put in through Paulson or Geithner or whatever, that's all the public debt side. You take a Federal Reserve note out and you look at it. It's like looking in a mirror. You've got a balance sheet. If you drew a line right down the center. But on a normal balance sheet, the right side is the assets and the left side is the liabilities. So, but on this Federal Reserve note, this balance sheet that you're looking at is like looking at it in a mirror because it's backwards. The asset side is on the left side instead of the right, and the liability side is on the right side instead of the left side. The black seal is where the money is, because when you're operating in the black, you're operating with the money. Which side is the black seal on? The left side. And who's the signer under the seal? One of them is the Secretary of Treasury. And that would be Paulson or Snow or Geithner today. But the one on the other side, that's the Treasurer of the United States. That's Anna Escobedo Cabral on the private side of the Treasury. Put them all in the wrong place, people. We want to put non-negotiable instruments in on the private side, not on the public side. We want to put them in the trust deposit, not under UCC. And we want to make it so that it's not commingleable into the public. We want to make sure that it's solely kept private. Then we want to generate some interest in the public that is drawn against those privately held funds. And the interest that is generated in the public, you can live on for the rest of your life if you don't commingle that and connect yourself effectively back into a U.S. traded business. There's where the 8 Ben forms and the 8 IMYs come in, but you can't use those forms per se because those forms are designed to get you trapped back up into the system, because you need to use a substitute form. The substitute form takes out all the garbage that's the minefield that's going to blow you back up, and you just put in the information that is on the instructions for the requester of the forms, W8 Ben series and IMY, because it tells you on that form there, the substitute form, how to make out that substitute form, and you only put the pertinent information in there that you need, which is solely private. Because all you need is really block 1, which is 1 through 5, identification of the individual or the entity. And the last part you need in there is the certification. Both those forms boils down to this. If I can find it quick.
Wow, thanks, Christian. A little dose of reality for us.
Here's the instructions for the requester form. And on the last page, page 6, I think it is, page 7. This is under the W8 IMY. It says, the last paragraph, it says in here that additionally the following statement must be presented in the same manner as in the preceding sentence and must appear immediately above the single signature line. Quote, the Internal Revenue Service does not require your consent to any provisions of this document other than the certification required to establish your status as, and then it goes on and on. But this is telling me that the whole purpose for both these forms, the W8 form series is that it's to set up the certification required to establish my status. That's the sole purpose of these forms. So I've established my status as a non-resident alien, and as a non-resident alien, I'm subject to withholding at the 30% rate unless I have the certification that I don't fall into that class. And then when you come in with the due diligence part in there, and I believe that was, see, that might have been the other form. No, that was page 4 on that same instructions. Page 4, the due diligence requirements. It says that you may, remember this is for the requester of the forms, that's them. So whoever's requesting this form from you, you may rely on the information and certifications provided on the form, including the status of the beneficial owner as an individual, corporation, etc., unless you have actual knowledge or reason to know that the information is unreliable or incorrect. You have reason to know that information is unreliable or incorrect if you have knowledge of relevant facts or statements contained in the withholding certificates or other documentation. Now, there will be other records, other documentation that would cause a reasonable, prudent person in the position of withholding agent to question the claims made. For example, if you have information in your records that contradicts information provided on the form, you may not rely on the form. So that tells me right off the bat that we got to go back and we got to start correcting some other information.
Yes, sir.
We got to go back, and who's that master record keeper? That's the IRS, that individual master file. And under the USAM manual, the U.S. Attorney's Manual, under 6-4.010, that basically says that all IRS records must comport, all other agencies must comport to the IRS records. And then my next question is, who is the one who makes the records? We do. We give the IRS all the information, and that's in their record file. We have the power to correct all that information. So when we effectively disconnect ourselves from being the surety of the straw man account, we're no longer the trustee on it, because they're the trustee, because we're using these forms the proper way, and there's no other conflicting information. When we do our special deposits and we don't cross it back over and commingle the funds, now they can go ahead and generate the interest and do the broker transactions and broker exchanges, which is on the last page 7 of the instructions on the W-8 Ben form. And then the trick is not to effectively get connected back up by making a trip up in the administration of the trust. The administration of the trust is going to have a knowledge of the use of the IRS forms and knowing what you're doing so that you don't conduct a business or trade in the United States again. So, does that answer your question?
So we're going way non-resident alien. We're flying Starship.
We're going completely out, yes.
Yep, that answers my question. I've discovered that they definitely show you how and where and why and the instructions to do that. It's just, I think I was really unclear about the fact that I feel like there's 3 of me. There's a U.S. citizen, there's a non-resident, and then there's a vessel holding some interest in the United States. So it feels like there's 3 different parties in my estate that I have to report for. And I think what you're saying is just a lot easier.
Well, I'm glad it's making sense to some people.
Well, the journey really has been to discern, like you said, the mirror of the way that the language is written and the instructions are written in the IRS documents. You really have to study them, and with another person, I'm noticing.
Yeah, it's they use a lot of verbiage that's what I call the portal terms. The Black's Law definition may have 3 or 4 different kinds of definitions.
Yes.
And depending on your circumstance, it could be construed under debtor-creditor, or it could be construed under trust. But they're using the same words. It's just like the word transfer. Well, transfer is a way of negotiation under UCC, which is debtor-creditor. And transfer can also be a trust term, which is one of the methods of formation of a trust. So that's the language. We have to know the language.
So the trust being expressed, as you were saying earlier, is imperative. The way that we're stating, the way that our private trust is working, it's imperative that it be consistent with what we're stating and how we're looked at and listed in the IRS records. This is all imperative.
Right. Because they're going to check, and if they see any conflicting information that doesn't match up with your W-8s, then they don't have to honor it.
Nope.
So when you request a set-off from a court case or something, trying to pay the debt for it and close and settle the case, they just look in the records and say, hey, we don't have to do this, because they've got information in there that's made it, and then they'll take and wait 90 days or 120 days for international, say, and then they'll wait to see whether or not you trip up again, whether you continue to do what you've done to effectively connect you back in. You never got yourself disconnected from the first place. But then going back, it turns out that you're under a protective trust, and it's totally discretionary to the trustee whether or not he's going to withhold or whether he's going to release it.
Can I say something to that? And maybe this is my last and final argument with someone who I know gets what my vision is and where I'm trying to go. One more devil's advocate here, okay? The part that you just said, what my vision is that if I assert an instrument with the default trust in place, okay, and let's say I've done everything wrong to now, but the default trust is in place, our forefathers put it together, and it's just there, and there's trustees taking care of business until further notice. If I put forth an instrument and it's dishonored for, like you said, 30 to 60 to 90 to 120 days, if I'm reading the instructions on the IRS forms right, and I'm really doing due diligence on my 1041, there's a part of me that believes sincerely that I can report that on a quarterly gain and loss return, and collect that on a refund back to me, back to source. And there's a lot of detail about that, how I would do it, but there's a part of me that with the trust in place as the default.
The key is the source. On that publication 515, it talks about the source of payments, interest, and what was the other one?
Dividends.
I forget the third one. But anyway, the big one is the interest. Yes, income, payments, and interest. The source of those. The source of the income, the source of the payment, the source of the interest.
The signature.
The source. If the source is from foreign source, it's not effectively connected with a U.S. trade or business.
We are foreign. Our trust is domiciled in Puerto Rico.
Well, no, I'm not. That's the straw man might be domiciled in Puerto Rico.
Well, right. I guess the foreign
Puerto Rico.
Yeah, okay. So if I'm doing it as a non-resident on behalf of, if I'm a trustee doing it as a non-resident on behalf of one of the people in my trust, which, I'm a multiple personality here, but there is a part of me is a non-resident, and part of me is a citizen, and then the other part of me is a vessel that is the creator settler.
I'm not going to agree with you there. I'm not the vessel. I am not the account. I have access to that account. I'm beneficiary of that trust.
Yes, we're sharing the rent. We're renters of it, of the interest.
Well, I guess you could look at it maybe that way. Yeah. I'm really not effectively connected with that in any way. I'm totally foreign. I'm a foreign person.
Yeah, I gotcha. Okay, I'm gonna go with that because I'm totally. It's perfect. I'm gonna go with that, and then I'm gonna keep studying, and then I'm gonna bring back to you what I'm seeing. But this is really, this is really great. Thank you so much.
Were you on the call last night?
No, I was coaching last night. I'll listen to the recording, though. I know there's a few people that were telling us about it. That's why several of us got on the call tonight.
Well, why don't you send me an email and put in there that, you're knowledgeable in the IRS forms.
Perfect.
I'll include you in some other special meetings.
Yeah, I'd like to send you some that I've journeyed through that are just blowing my mind.
Okay, thank you.
Yeah.
Anybody else have a question? Mute out *6, and then if you have a question, unmute yourself by pressing *6.
Chris, you can hear me?
Good.
This is Jim.
Jim, okay, go ahead.
How are you? Hey, back to the removing the trustee's discretionary power relating back to the 1776 war debt. It seems to me, and again, I'm looking at this really simplistically, but it seems to me that you've got it pretty close to nail on the head. In simple trust law, because we are the beneficiary, if you were to, say, tender a letter or a payment order to the master accountant, and that very well may be Cabral in this instance, and make an order to pay your immediate fair share of the debt,
issue a non-negotiable private money order and have them fill it in, you'd be doing your due diligence to complete your payment of debt because we have to be solvent.
Right.
So wouldn't that, I mean, ostensibly, wouldn't that go to, you mentioned something where the IRS is master accountant, but then when you're right, when you look at that bill, it's a reverse, it's a mirror. So wouldn't that letter go to Cabral?
Yeah, that's what I'm saying. We've been
sorry, I'm sorry.
the wrong side.
Okay. Yeah, I'm sure you're going to have to do a follow-up to this call, but I'm going to do a little bit of research on that because I would think that's where your remedy lies, right there.
You know that the portraits on all the dollar bills, all the FRNs, everybody says they're dead presidents. They are not dead presidents. I will tell you what they are. They are all dead postmaster generals. That tells me that all those guys were head of the post office. The post office goes pre-1776.
The original seat of government.
Many people, they don't know that the post office was a bank because when I was a kid, I had a savings account at the post office. That's a bank. That's the private bank of the real man. That's the black seal side on the Federal Reserve note. In 72, I forget exactly what year it was, the post office was taken over by the United States Postal Service. But the names on all the buildings are still the post office. Now, if you try to look up the post office today, it don't exist under, there's only 5 heads running the post office today, and they're all in D.C. But it's still there.
And that's one last thing. With respect to your status as non-resident alien, and in some of the ways that you address that, have you researched the lack of limitations and restrictions that are placed on national? You look at the U.S. Code. Yeah, there's no restriction placed on national. There's no limitations. There's nothing attached to a national.
Mm-hmm. Well, as a non-resident alien, as a foreign person, if I don't have any income, I don't file 1040 forms.
Right.
No income to declare.
If you look at a U.S. passport, in the first sentence, it's going to quantify that this U.S. citizen / national, and that / is a virgule, and it means or. So you're either a U.S. citizen or you're a national. And that carries weight to it. I've actually used that. And the term national, nowhere in the U.S. Code are there any restrictions or limitations placed on a national. So that's how I've gone by for years.
You still got to be careful of using that term.
Why's that?
Well, because the thing is, if you look under national, you could go further back. What you have to actually claim is because anytime you use the word citizenship, it is synonymous to allegiance to. Just like what most people don't realize, what they how they're getting tricked into being U.S. citizens is through the voters registration question. Number 2, are you a U.S. citizen? Because what it's defined, where its territories are, what the other states are, but further than that, once you sign that form, is you are technically an alleged felon under Title 18, Section 911. It says whoever willfully knowingly identifies himself to be a U.S. citizen and is not is guilty of a 5. So you're just alleged, you're just not convicted. But the national part is actually under Title 8. I think it's 1101, which you basically state is that you are a state national, pre-14th Amendment. Because you still have to understand where the allegiance to, because then you're getting into the de facto, well, is your allegiance to that state government, or is it to the federal government? Either way, you're still subject to that. Now, you can even take...
Or is it to the Republic of California government?
Well, you're talking de jure government now. That's a whole different thing. Or you could even take it even further, because under Public Law 97-280 through the Reagan era, remember what he did is that they deemed the the Holy Bible as the Word of God. So then you could use the Bible under Matthew 5 is that you are a citizen of the kingdom of heaven. There is a foreign sovereign nation, which is heaven.
That's what's on my UCC.
Comes back to we have to guard our signature. We can't ever give a unrestricted signature. We got to give a qualified signature.
Well, yeah, because you're always put under that assumption of same pot with everybody else. Now, there is supporting cases, just like one in Florida that went in bank, and that's under Pally v. Pally. That's Pawley, and it was a divorce case. And just to emphasize what he was saying was, I am who I say I am. And a typical way that you could even correct your status, even by not even going through the IRS. Well, the first thing you have to do is revocate your voter's registration. The second thing you can also do is what's known as a declaration of domicile, but you never use the forms that the counties generate because that puts you back into a contract. And they use various terms such as residence, different type of terms. You got to be careful of it, where basically I live in a domiciled abode, which is totally different from a residence of everything that's done. But you can do your own, just like in Florida. And Christian, you probably verify this under it's under the section of exempting homestead, but it's under 222.17, where under subsection 7, if you look very closely, it says that there is nothing that can obligate you from doing your own form. Once you do that, and then you give notice to, and have the same thing up to the Internal Revenue Service, because remember, there are situations where you do have to pay taxes, and it falls into those categories, such as if you're born within their territories, if you're a federal employee, if you derive an income from outside the United States, if you are a seaman, if you hold a special license issued by the federal government, such as manufacture firearms, alcohol, and tobacco, or have corporate earnings, then yes, you fall into those categories. Outside of that, there's no law that is a direct tax, because in order for a tax to be direct, it has to have apportionment and ratification by 38 of the 48.
Right. All this is through the administration of the trust, though, and really we got kind of the cart before the horse. We're trying to get disconnected first.
Right. I understand.
Well, Jim out. Thank you, Chris. I appreciate it. I'll be on the next call. Thanks.
Okay, great. Anybody else have a question?
I have a couple of questions.
Who's this?
First of all, is there a way that we can get up to speed for those that are tuning in late, so to speak, and get all the background that you've gone over before?
Yes, if you'd send me an email at moving titles, that's one word, moving titles at...
Yeah, I got an email from you, so I'll do that.
Request the downloads.
Oh, the download. Okay.
Yeah, request the download audios.
Can you repeat the email for those that don't have it?
Again, it's hushmail.com. It's moving titles, one word. Moving titles at hushmail.com.
And the subject line should be?
Yeah, request the audio downloads. I'll send you the links to get the downloads.
All right, great. Now, secondly,
get the book. First law summaries, the trust book. $30.
What's the name of that?
Gilbert's Law Summaries.
Well,
Get the one that's on trust by Edward C. Halbeck, Jr.
Okay. Now, secondly, would it help to do a revocation of original election relative to the IRS?
Well, there's different ways of doing different things, but I'm going to stick with forms that the government is going to recognize. I'm going to stick with, say, IRS forms, GSA forms. I'm going to stick with, the whole public system is set up for forms, process, and procedure, where on the private side it's all about substance. It's all about the real substance of the real man. So that's
okay.
So I'm going to give them something they're accustomed to seeing. Give them a form.
But my understanding is that if you even admit to a first name, last name, then you're automatically giving them jurisdiction, are you not?
I'm not admitting to that at all. I'm disconnecting myself, and then once I'm disconnected, I have to make sure that I don't act in a way that I'm going to effectively connect myself back in under commerce again. So
I understand.
U.S. business or trade.
Right, but I understand that. But if you admit to a first name, last name, are you not then acting as surety to the vessel?
No. That name's not me. That's some nomenclature they've come up by idem sonum.
I understand, but all the forms contain that those little boxes.
Okay, but I have to make sure that I'm not, that's part of the administration, knowing how to fill the forms out. Because you could fill out this W-8 Ben form, the 8 IMYs, make it out the way that it says, and you've effectively connected yourself back in.
Exactly.
Here, all along, all we had to do was read this other instruction form that said, hey, we could do a substitute form. In fact, we can even just put the information on our own form.
Okay, well, that was my issue, is that my understanding is that if you do use their forms, they're, of course, very cunningly designed to entrap you.
Right. I'll agree with that. So I have to actually know what I'm doing. I'm only putting enough information in that it's required, and it really says that the only thing needed is to identify the individual or the entity in Block 1, Part 1, and all it needs is a certification, the last part. Because the certification was the most important part, what it said in the IRS thing. And what was that that you're certifying on that form? There's the certification part. So first of all, I'm declaring. It says, I declare. And nobody declares except a real man.
Yes.
And a declaration is also one method of formation of a trust. Right. There's a bingo right there. And it says, number 1, that I am the beneficiary owner, or I'm the authorized to sign for beneficiary owner. So there's the authorized representative. 2, the beneficial owner is not a U.S. person. And 3, the income is not effectively connected with a conduct of a trade or business in the United States. And it says it's not subject to tax under an income tax treaty. And 4, a broker transaction or a barter exchange. And the beneficial owner is exempt foreign person. Blah, blah, blah. And down here it says that I authorize this form to be provided to any withholding agent that has control, receipt, or custody of the income of which I am the beneficial owner, or any withholding agent that can disperse or make payments of the income which I am the beneficial owner. Hallelujah! So that's all it was needed, Part 1 and Part 4, the certification.
Now, my understanding is that beneficial owner, the way they define it, gives them jurisdiction.
There's a minefield in those forms. But in every minefield, there's a secret path that's safe. And that safe path is, I want to be a foreign simple trust. Foreign simple trust, by the definition, is the beneficial owner is the beneficiary. In the instructions, grantor trust, foreign grantor trust, it says in some of the other publications, you got to catch it, dig for it. But it says if you got a small trust of 5 or less, you got to have an EIN number. If I got an EIN number or a TIN number or an ITIN number, I've effectively connected myself back into the U.S. business or trade. A real man does not have a number. So don't get a number.
And how do you get past that on the form?
Read the instructions for the requester of forms W-8 Ben and WIMY. Look under the substitute section. Read that whole instruction. The substitute form. You want to look up on it's hard to find on the IRS. do a search on their website for the catalog number. Put in CAT and NO, catalog number, and put in this number, 26698G, as in God. 26698G. Do a Google or do a search on their website for that catalog number, and you should get the instructions without any problem. Otherwise, you may spend days on there searching for it. They don't particularly make it too easy to find that one. I wonder why.
Hey, Christian, the number for that to find that is publication 1281.
Okay, great.
Okay.
Anybody else have a question?
Muting canceled.
Press star 6, state your name, where you're from.
Christian, this is Terry from Louisiana. I have a question.
Yeah, sure. Yes.
Actually, a couple. Going back to expressing the trust, do we A for V the Declaration of Independence before sending it for the apostille?
That may be one way of doing the acceptance on there, but a signature is an acceptance also, and I would sign the thing with an allonge and attach the allonge to the document.
And what is the allonge?
Well, it's like an attachment to your note. It's the signature line, the signature pages, the endorsement pages.
I'm not following.
I wouldn't want to ruin my document after I got an apostille with the fancy ribbons and all that stuff on there by putting accept for value across the top. What I'm going to do is I'm going to do an acceptance on the allonge page and attach the allonge page to the whole document and get that apostille.
So that needs to be part of what you submit for the apostille.
Right. Mm-hmm.
I sent mine in without anything. Okay, I'll have to try to correct that. And when we do an A for V on it, on the allonge, what qualifying signature do we use? By grantor?
Well, I could put grantor/beneficiary.
Okay. And what exact verbiage do we use for that A for V?
We may have to work on a little bit different verbiage than what everybody's accustomed to. I would make it kind of like a declaration of acceptance.
Okay. And that's something that you're going to be sending out or discussing very soon?
We'll be on that in the workshops.
Okay, great. And last question, on the UCC1, we list each of these three documents separately. And do we also list that they are, for example, the declaration is certified and apostilled with an accepted for value, signed by grantor beneficiary, etc., etc.?
That might be too much information. I just want to make maybe reference or notice that the documents exist and are held in the private. You know, this is actual constructive notice that such and such number, maybe I might want to say something about it for a title, has been, you know, is held in the private.
And list each of the...
Claimed and is held in the private, and all proceeds from it, you know, I'm claiming it.
Okay. Again, I guess you'll discuss that in the workshop.
Right.
Okay, thank you.
You are now muted.
Have a question? State your name, where you're from.
I have a question.
That's who's this?
Yeah, it's Kenny again.
Kenny, okay, go ahead.
Just want to have you go over, and I'm sure that many of us can come up with examples of it, but maybe you could throw out some of the more obscure examples of once someone is effectively disconnected, what are some of the acts and or behaviors that would cause a reconnection?
Okay, if you get Gilbert's Law book on trust, some of the later parts in the book talks about the administration of the trust. And under the administration of the trust is accounting. So we have to know how to use the accounting forms that the IRS is using to effectively make sure we don't connect ourselves back in with a U.S. trade or business. We have to start our signatures what we're signing and ask the question of every time you're going to sign something, what relationship are we forming here? Are we forming a debtor-credit relationship, or are we forming a trust? I better be forming a trust, because that would be in a form of expression of the trust, because every transaction today has to be a trust, because there is.
What section of the book is that? I've got it now. What section is that?
Without me looking, you'll just go through the index. It talks about, the administration of the trust.
Administration. Okay. Thank you.
And if I could just make an addendum to that, study the publication that goes over the estates and trusts that the IRS put together, because they do a lot of references to the codes, to the UTC codes. They do a lot of references to the regulations, which will do all the language of the trusts and estates and the management therein.
Right. Keep in mind that this Gilbert's Law Summary is also a statutory trust book. But what I'm doing is I'm teaching statutory trust, but what I'm doing is I'm teaching you the black. So when you know the black, when you see white, you'll recognize it in an instant. And
That's right.
Is the private trust. But this book, Gilbert's Law, is a statutory trust, a public trust, but yet it's a very good example to give you the ideas of how they're trapping you up, what they're doing, and how you should be acting, because it's the same on the private side almost.
Keep your friends close, but your enemies closer.
Okay, another question?
Christian, this is Doug in North Carolina.
Yeah, Doug, go ahead.
Besides the debt from the war, there might be some personal debt we could also pay by canceling or tendering a 1099-C for all the past total earnings we've created by charging for our labor, which the Social Security has. And you can ask for that.
Why we might not have success at that is because we really haven't paid the original war debt. We haven't paid our fair share, and then the trustee has discretion to honor our OIDs or whatever else we got in there.
Well, will we have to do that as well? And so I'm wondering if...
No, I think you do the effective cutoff first, and then once you've established standing and claimed the trust and proved the trust, then you can come in and pay the debt. Once the debt is paid, then the next thing after that is you can start doing any other personal debts that you've incurred.
Okay, so then we could use the SSA 7050 report and do a money order against that to pay that debt.
Yeah, you could use well, I don't know about the SF series. You want to make sure that they're non-negotiable instruments. Because once we get out, we don't use anything but non-negotiable instruments.
Well, what about a 1099-C, which is a cancellation or a forgiveness of debt?
That could work.
Okay.
You got to get them in agreement to do that. Who's the one that's obligated to do that?
Oh, the IRS, probably.
No, the one who holds the debt. You think England's going to absolve you from the debt?
Well, your debt, you're liable for all those payroll checks you endorsed.
Yeah, that's true, yeah.
So who's holding that liability? I mean, who's the creditor?
Public debt side stuff.
Would that be done would that be covered with what you're talking about, a money order, a blank money order to the IRS?
Well, really, once I'm out, I'm going to write a check from the interest on account that I have that is held on the public side. And you would just write a check, pay the debt.
Okay.
And nobody's the wiser.
I see. Okay.
So you're functioning like through this straw man or this LLC account that looks exactly like everybody else, except your source of your interest is on the private side.
Yes. Okay. Thanks.
Therefore, it's not effectively connected as taxable. Next question, anybody?
This is Kevin. Can you hear me?
Yes, Kevin, go ahead.
Yeah, hi. I'm the founder of the Anti-Revolution Yahoo group, and I'm kind of a newbie to your information. Although some years ago I did kind of think that something like this would be the answer. I just heard like one of your shows, but I wanted to know, when you express the trust, these are some simple questions. Who is the beneficiary? Who's the trustee? Things like that.
Well, in different scenarios, I'm probably going to be functioning as either grantor and beneficiary, or maybe possibly grantor and trustee.
Okay. Now, here's my take on it, not on what you were saying, but I had an aha moment when I was listening to you, and that was that and weren't you saying that we should be the trustee, and what I was thinking who could be the beneficiary would be the United States government, a.k.a. the free inhabitants of the 13 colonies and all others admitted on an equal footing, something to that effect. And then basically going back, since we've been managing this corporation that they created for them without pay and incurring all this liability, we've never gotten really paid right from like the day we turned 18. So it seems to me like our lien against the account would be for all those back wages. And if we were
said account, because all I'm going to do is make a bigger debt.
Uh-huh.
The trust really the United States, although since we didn't express the trust, they should us to be the trustee. And there's where the problem is. Now, if we come back in, re-express the trust, and restate the positions of the parties, correct the misconstruement that we are not the trustee, we're the beneficiaries. But first we'd have to do an establishment of the claim and have the information to prove the trust in order to have that standing to do that.
So we're trying to say that we're the beneficiaries.
Yeah,
and they're the trustee.
Press *6, please. Go ahead.
Okay, I have another simple question here. Where do you get it that the negotiable instrument is on the public side?
Well, all negotiable instruments, UCC 3, or they fall under securities in 8 and 9, and all UCC is public. It's all according to GAAP, which is running, the rules. So negotiable are all public. The only thing that's not public doesn't fall under UCC is not negotiable. Why do they have that little block there on the UCC form that says a non-UCC filing? Another question?
Christian, this is Jack from Louisiana.
Go ahead, Jack.
I want to ask you something about the mortgages. I'm also somebody who's fairly new to your process or the ideas that you've come by. I've been doing some research. I've listened to one of your calls before, and I'm a researcher. I love to go to the law library, and I listened to one of your calls one night, and you were talking about the special deposits and the commingling. I went to the law library and did a lot of research on the special deposits and the commingling. Found a huge amount of cases in support of that, and the special deposits compared to the general deposits. When you and you sign a promissory note or a note against your mortgage, and you give them this, I'm a little confused on exactly what goes on with that note as far as when they take that note. I'm actually I have a copy of the original promissory note that I did for my closing, and I actually have the back of it where it's stamped, paid to the order up to the bank. So I know they deposited it, and from my take from what you're saying is it went to it was a special deposit. And my question is this: if number one, if they've taken this and they've deposited it and they're holding it, can't you give them the instructions to take? Because this is where you hear that they'll claim that the note has been abandoned, and that's where I get confused if it's been abandoned. So if that's the case, can't we just give them instructions to process the note from the liability, from their asset side of the bank to the liability side, and discharge that debt?
Yeah, the old information about the abandonment, it really falls under debtor-creditor. Now, that works under debtor-creditor to some degree, but, if I claim trust, and it should be a special deposit, if they securitize that note in any way, so if you've got a claim coming in from the bank and they coming at you as trustee of such and such securitization pool, you know for a fact that they've securitized that note. And that's going to breach the special deposit right off the bat, and you got them. Because
they're moving against me right now in the executory process here in Baton Rouge. They're trying to come after me. Louisiana's got executory process here. Just all they got to do is go in and file right into the court. They don't even have to notify you. They go in and sell your house. And I caught them, and I put some paperwork into them. I've shut them down, but I was really concerned about that. That right there, I felt like I had something there. And there's a ton of information in the law library, especially if you go into words and phrases and the corpus juris secundum and stuff like that on the special deposits for trust,
right,
and the express trust. And so you're saying that since I have that where they deposited, you feel like I have them?
Say that last part again?
You said since I have a true copy of that showing where they did deposit that you feel like I have the upper hand on them?
Well, I was saying on a complaint that the bank comes at you with usually has, the captioning of the plaintiff is such and such a trustee for a securitized pool.
Mm-hmm.
It gives you the pool number, like 2006 XYZ something. But the trustee.
Yeah, well, I've got the pool number too because where they signed the back of the note and deposited it, they also had a notary notarized it.
Well, if you can transfer payments into the pool, then you've got some trail that you can prove that it's been securitized. But you need some kind of proof that it's been securitized. And I don't think just an endorsement is going to prove that.
Well, I've got the assignment sheet that came with it. I went and pulled that out of the record, and it has the pool number on there.
Okay, well, great. If you can look it up and get some actual public record information that is going to be not hearsay in court that you could use and get around the hearsay rule, then you got some pretty good evidence. You got some exculpatory evidence.
Yeah. Well, I appreciate your time, and I'll defer to somebody else.
Yeah, that the whole thing was in the mortgage, we did take and express a trust, and they knew that we probably weren't going to do that. But then they figured, okay, we're going to have some kind of insurance policy on this, just in case you don't express the trust and tell us to take the note and cancel out the debt. So they make you sign this unconscionable contract, which is an insurance policy, that if you don't say that, then you got to pay the note back for the next 30 years. And all you had to do was express the trust at the beginning, or maybe now, 5 years later, you can come back in and re-express the trust again. Claim the note on the UCC forms. Take and merge the titles in the entity because the bank. I keep going over that one case from the Kansas bankruptcy that said that the trustee, or not the trustee, the trustor is the signer on the note, which is the grantor or the settler, and the payee on the note is the beneficiary, who is the bank. So the bank has set themselves up as beneficiary, and they knew that any entity in a trust can't be simultaneously the beneficiary and the trustee. So they got a power of attorney from you, from your application of the original mortgage, that they got the power of attorney to appoint a title company to be the trustee, to a separate entity. So the trustee, the title company, is holding the legal title and then the beneficiary is going to hold the beneficial title, and the two entities are separate. Now, what you want to do is you want to merge the titles into the bank as the bank being beneficiary and trustee. Now, when any entity is holding both sides, the trust terminates. Now the bank is caught without any trust protection, and they're going to be more apt to settle with you and give you the house back and maybe even some damages for the whole thing.
If I send you an email, could you, regarding that Kansas case and that, would you be willing to send that information to me?
Yeah, go ahead. Yeah, email me and request that.
Okay. Thank you, Chris.
And Christian, also, Keating, this is Kimberly. Keating talked about the call sheet, that you can actually request the call sheet from the bank, and it shows the actual time and day that they transferred the money. And if they did it within that 3 days, then that's the whole thing. That's the whole case they've got in Kansas City with mirrors right now.
Yeah, but I did a wrestler on these guys and gave them 60 days. It's been a year, and they still haven't responded to my wrestler. And I requested all that information because they're not wanting to give it to me.
Well, have you done a show cause hearing why they haven't?
No, this stuff just came about a week and a half ago where they did the started the foreclosure. So I'm scurrying around here trying to figure out what I'm going to do.
You got an independent action against them?
No, I'm getting ready to put that against them.
Yeah, come in with a counterclaim and maybe file an injunction, get them to stop all the proceedings until, this is adjudicated. I do an administrative remedy and get them in a default and dishonor from this notary certificate and some kind of thing like a debt validation under 9-210A4 statement of account. And then come in with a 9-625 with the estoppel and damages. But anyway, the whole thing is going to create a unclean hands doctrine, and the unclean hands doctrine, they can't come into a court of equity and ask equity to do the same thing if they got dirty hands themselves.
Yep. And I already know they're doing that. What? Real quick, Christian, what was those nines again? 9 what?
9-210A4, that's asking for a statement of account in 14 days, which is kind of like a debt validation. But I'm going to put in the statement of account, and I'm going to say, well, I say that the account is 0. I don't owe anything. Now,
okay, and the other one?
14 days, you have your notary certify that the thing is 0.
Okay, and then the other one was
9-625, that's the estoppel and damages. But that whole scenario, once the notary certifies that creates the unclean hands doctrine. And you should be able to get an injunction or a temporary restraining order stopping them from any action, and then come in on a mortgage foreclosure where it's an equitable proceeding where the court is to, the assertion may be refused, the discretion may be refused to grant a foreclosure of mortgage for equitable reasons because they can't ask a court of equity to foreclose on you if they got dirty hands. So if they intentionally fail to act in good faith or deal fairly with plaintiff, comes in the court with the unclean hands as a result of the specific act or the omission from the notary certification that they didn't answer you, and that's a material fact of equity that the court can't refuse to hear, and then they can't allow the court to foreclose, or can't allow the plaintiff to foreclose on you.
Okay. Thank you very much.
It's pretty powerful right there, just in a litigation.
Hey, Christy, this is Eric. Can you hear me okay?
Yeah.
Hey, a few minutes ago, somebody mentioned something about last night's call. I was unaware that there's a Monday night call. Is that a regular thing now?
No, that was by invitation only, really.
Okay. And somebody mentioned something about an allonge. I think you did. Now, how would you spell that? And is that something we can look up in Blacks and learn about?
Yeah, I think it's AOLNGE or something like that.
Okay.
AOLONGE.
GE, okay.
That's French.
2 L's.
And what would be the proper way to express the violation of 9-336 when they commingle our notes and lose security in the property and when it transfers to the pool?
Do you have 9-336? Do you have official comments? Because it pretty well explains it in there.
Okay, I'll look that up. That's all I got. Thanks, guys.
Oh, will you be doing a Saturday night call, Christian?
Yeah, I'll be on Saturday. Yep.
And then are we going to do Tuesday? Is Tuesday going to be the regular thing, or are you going to go back to Wednesday?
Well, I'll be on Wednesday also, but I'll probably be doing the Tuesday call.
Okay. So,
It'd probably be a regular thing.
okay, so is it going to be a different number for Wednesday?
Yes, because that's on TalkShoe, and this is an independent one here.
Okay. So same number as before on TalkShoe?
Yes, that's really the Neo Morpheus call. Same time, 8 o'clock Eastern.
And can we get a recording of this call? Because I got in on the call late. Will that be posted somewhere?
It might take me a little while because I got to edit it, and I got to see if I still have it. Yeah, I got a whole board of stuff here that I'm trying to learn everything all at once, and I'm a little lost on some other stuff.
Yeah, because tonight's call with Remedy is something I really wanted to hear. I just got in late because I was thinking it was a Wednesday night number by the time I got in on it.
May change the time to 9 o'clock on Tuesday. Tuesday will be a regular thing, though. Another question? Press star 6 if you're not speaking.
This is Ken from California.
Go ahead.
Is there a distribution list or an email list that one can join to be informed as to when these calls are being hosted?
Yeah, if you send me an email at that email address, movingtitles@hushmail.com.
Mm-hmm.
And if you're not on the list, I'll see it and I'll put you on the list.
Okay, thanks.
If you don't have the downloads for the other past shows, request the link for the downloads. I'll send you a copy of the link sheet.
Thank you.
Christian, and to further the process with once they're into a situation of estoppel, once we default them, if we were to file that into the public record, at 91 days, does that estoppel on that notice of dishonor, if you put a true bill on there, does that true bill become an accounts receivable if you file in the public record on the 91st day? Or would you actually need to do a lien?
A lien, yeah.
Okay. And would you recommend just... Go ahead.
Is it private?
Say it again, please.
The trouble is it private side or is it public? Because if it's private side, it doesn't, have any effect on the public side, and that's why, some of this stuff doesn't work right.
Are you talking about for the initial presentment and then the notice of fault and then are you talking about the true bill that's private?
Well, the whole thing becomes a lien, which, is really private by administrative process. But
so then
it's over, you have to take it in on the public side and, do the enforcement on it. But now I would treat it as a trust. I would put it in as a trust deposit.
The true bill, you mean?
Yeah, the whole asset. What you're doing is you're creating a negotiable debt instrument, but is it going to be negotiable or non-negotiable? What side am I going to stick it on? How am I going to use it? Am I going to use it as debtor creditor or going to use it as trust?
So based on everything you're talking about, it sounds like we're going to be better off to go the trust route.
Yeah, absolutely. There's where the 900-pound gorilla is. That's me.
So that's a simple situation of once you get to court, do a notice of interest, even if you have the estoppel, to bring it into chambers to go ahead and handle it on the private side.
Well, I could turn the case into a trust.
Okay.
I really don't need to have a financial asset. I would turn the case into a trust. It's a trust anyway. All I need to do is get the elements there, and then one of the methods of formation, I got a trust. And then I've expressed the trust and claimed the trust, proved the trust, and I'm the 900-pound gorilla in the case.
And then merge the parties.
Either that, or I could force the trustee to do his duty, which is disperse the funds.
And would you assign, for example, the plaintiff, the attorney for the plaintiff as the trustee?
No, the judge.
Okay.
When he refuses, then I tell him he's got to appoint a successor trustee and let me know who it is so I can transfer trust res to that trustee. Because at that moment when he refuses, a resulting trust is formed in court, and the court of equity will not let a trust fail for a lack of trustee. He's compelled to appoint a new trustee, or else he's in breach of fiduciary duty. Breach of trust. He's got a right to refuse, but I don't really care. Appoint a new one. Appoint a new one. New trustee, Judge. I'll wait.
And under the rules of trust, must he appoint a new one?
Absolutely. That's what Court of Equity says. Court of Equity will not allow a trust to fail for a lack of a trustee. That's equity.
Okay.
That's where trusts are. A definition under Black's Law, or under constructive trust, says the equity is the conscience in the court where it lies, the trust, under right title and interest, which is really the 3 clicks of Dorothy's shoes to get back to Kansas. She had the shoes all through the movie. She had all the power, right, through the movie. She just never knew it. Same way with us. We got all the power, we got all the rights, we got all the titles and interests. We just don't know that we are the grantor. Any other questions?
Christian, this is Susan in Georgia.
Yes, Susan, go ahead.
In reading over the Bank Officer's Manual for Commercial Banking in Section 19, it states that a mortgage, even though the terms of trust and grantor and the other terms are used, is not identified as a trust unless a trust is implied. Or the word they actually use is express.
Uh-huh. No, that's statutory.
Excuse me?
I say that's statutory now. But no party in the trust needs to know or understand they are forming a trust. Now, that's a grantor, trustee, or beneficiary. But that does not negate the fact that the trust was formed. Now, that's Section 23 in the Restatement of the Seconds Law on Trust. That's also in Gilbert's Law Summaries, page 19, at Section 67.
Okay. Also, for those of us who were on the call last night, if we wanted to re-listen to that call again, is there a way we could do that?
Okay, yeah, I just finished editing it today, and I thought I lost it too, but I got it.
Oh,
I did lose, like, the last 2 hours, but the most important part was the first 2.5, so I've got that.
Great.
We'll be posting it up on the site there, and then give me a little time for that, and then request it. It'll be on the new downloads list.
Great, thank you much.
Well, let me ask you this. What did you think of that call last night, if you were on it?
That was probably one of the best calls I've heard in a long time and opened up many, many doors.
Any particular points?
The biggest point about it was actually being able to use the non-negotiable instruments in utilization with the private side of the banking, and how that would fit in and change the whole perception of all the things that a lot of us have been going through and have learned, to take that and apply it, and it just cleared a whole lot of things up.
From what you said, it sounds like it.
Yeah, it really did. It really was like a light bulb.
Great.
And
great.
I appreciate it. And thank you.
If anybody thinks that they're up to speed and they would like to be on a special call, the title of that call was How to Negotiate a Negotiable Debt Instrument with NTT as New Trust Technology. But actually the title was kind of a misnomer, because we don't want to operate with negotiable debt instruments anymore. We want to operate with non-negotiable debt instruments. So anyway, if you think you have a higher knowledge, send me an email that you think you're qualified to go on with some more meat to just the basics. That call, then send me kind of like an IQ quotient of yourself, what you think, and so I'll send you an invitation, say. Anybody else have a question? Anybody else have a question? Press *6.
Christian, can I ask you another question?
Yeah, go ahead.
What would be your approach in a situation where there is an approved short sale with Bank of America, and even through the administrative remedy that they did not respond, but to be going in as the seller and into the escrow account with an addendum to the closing to proving up the note in order to close that short sale? My objective here is to bring them to the table. Administrative remedy they would not listen to, and all the processes that have been going on with their revocation of attorney, of course they ignored, etc. And instead of going through because it's a very short period of time, the express trust, do you think there is an avenue to catch them through the escrow closing instructions to bring them to the table at the time of closing?
Well, first of all, I think I need something on the private side of the court, or public side of the court, excuse me, to jam them up and stop this whole process, to buy you some time and things. And I would be doing an administrative debt validation, like I told that other fellow, under 9-310A4, and create the estoppel by the notary under the unclean hands doctrine. Because once I had that certificate under unclean hands, then I can go in there with an injunction. I can get an injunction.
Well, this is in a non-judicial. This wouldn't be in a judicial state because it's not in a court system right now or a court hearing right now. It's just that the short sale has been approved to be closed, and
you can file an action, come at them with a claim, which is really my counterclaim of the unclean hands, say, and get the injunction to stop the whole proceedings.
If I do that and they throw the short sale out, I'll lose the buyer.
You're going to have to weigh that. In the long run, you're going to come in with the trust and get it all back anyway. And even if it does sell, say even in a straight foreclosure, you can still get it back, or the funds.
So even if I go through a short sale and sell the property, I can go back after them after the fact?
Yes, right. Mm-hmm.
Okay. But you don't see of anything that I could put in the closing instructions that would put them up against the wall, because the attorneys that I'm using on this are pretty strong attorneys. And since I just got the approval and we're ready to go close, then I was looking at an approach of something to the effect of doing an addendum to the closing that the seller wants to make sure there's no representment of the promissory note after closing, so therefore the original closing or the original promissory note and the loan is going to be required front and back at the time of closing.
Okay, so you're asking for the note back?
Sure. That's what I'd like to do.
Are you coming out ahead on this deal?
No, I'm not with reference to what they say the payoff is, no. It was really ironic because when they finally approved it, their net payoff was less than what they originally said it was. Quite a bit, actually.
Are you satisfied with what is going down now?
I'm satisfied in that my original satisfaction was just to get it off my plate, but as I became more educated, this short sale's been going on for about a year. And I've just recently gotten the approval.
Yeah, because some of this stuff may ruin doing what you're trying to do. It might throw a wrench in that also.
I'm not following you.
Well, I mean, if you're satisfied with what's going down, you just want it off your plate, time being, until you come in maybe later on and do something. But then I would make sure that I protected myself, that I don't have any clauses in there that says that I can't do certain things.
So
they're going to give you the note back. I might want to try to play this through trust, and actually treat that as the special deposit that it didn't close at escrow closing. So I'm going to come back in and open it all back up again.
I don't think they can't provide the note I don't feel they can provide the note anyway. This is going to be a Mears Bank of America scenario, and my position on this is or my thoughts on this is that they can't produce the note. Therefore, they're going to fault on the closing, and then let the closing attorneys go after them for lack of performance.
Okay, I see what you're trying to do. All right. Yeah, you could do that, but like I say, I like the trust approach better because I'm trying to pull myself out of all this debtor-creditor stuff and litigation and all that other stuff. I like the trust approach better. But, if it saves you from, if it saves you now, then, maybe you should go through with that and complete that first.
Or could I go ahead and imply the trust and let them know and that the trust is in place and designate myself as the grantor beneficiary, so when they go to closing, then at that point in time, I would have that position in place, because it's been real obvious to me that in that financial institution, the right hand definitely does not know what the left hand is doing.
Okay. It's up to you which way your knowledge is going to direct you to go. Whichever way you feel more comfortable with.
Well, I appreciate your input on that.
I like the trust approach because that's where really all the power lies. It's just the fact that I never expressed it being a trust. And we put the stuff into the case under those other trials that we did, and we had those 4 lines in there expressing the trust and the footnotes. But since then, that was nothing more than just an NOI. We really didn't have the SOIs in there. And the SOIs is the more important. That's the material fact to prove the claim that there is a trust. And we've come a little farther now, so and some verbiage on how to put a little more detail in there so that there's less construment.
Right.
Okay, anybody else with a question?
Hey, Christian?
Yes, who's this?
Hi, this is Carlos in California.
Hi, Carlos. How are you doing tonight?
Fine, thank you. Thank you, sir. I didn't get a message yesterday from the yesterday's call. Did you record it?
Yes, I have a recording of it, yeah.
Okay. I'll shoot you an email on that, please. And also, if we have Jim on the lines, one of the lines, can I give my email because I have an important question for him?
Yeah, go ahead.
Prosper, 4, LESS @hotmail.com. That's PROSPER, 4, LESS @hotmail. Thank you, Christian. Good job.
No other questions?
Christian, I have another one.
Okay, go ahead.
I'm in the process of sending out documents to the IRS for accepting for value. I have a payoff statement for my mortgage in the hopes that that's all going to get cleared out. But still, even if that gets paid for, then the bank is going to be paid, but they're still going to hold the note. So if they don't return the note to me, what can I do to compel them to either get them to pay me for the value of the note or return the genuine wedding signature promissory note to me?
Express the trust, treat it as a special deposit, and then give the orders to disperse the funds.
Right back to square one. And is that something I do in court, or is that something I would do in chambers, or is that something I would do by written presentment directly to the lender?
Well, Well, I'm probably going to have to prove, if it's in a court case, I'm probably going to have to prove that I am, say, grantor or beneficiary. And that'll probably have to be in chambers so I can prove to the judge, I am grantor or beneficiary. Once that fact's been established, then, hey, I'm the 900-pound gorilla in the court. So it'd be, private chambers, motion protective order, CCI information on a private side of the court, the public motion to order the court what to do, the in-camera hearing, and make sure they don't cross the information over to the public side of the court.
So is this something that I would file for a hearing for and then do the NOI and then go on with the process you just described?
Well, the NOI would probably be nothing more than a public notice to the court that I'm claiming that I am the beneficiary or the grantor. But then the SOI is the material fact. That's the CCI information that has to be kept in chambers and protected.
But to get it started, it would be to file an action and then do the NOI to bring it into chambers. That's the way to get there? That's the path?
Yeah, that's the way I would go, yeah.
Okay.
Christian, I got a question. Would it be, in order to get like a writ of replevin?
I believe a writ of replevin was the court waiting to find out proof of what status the parties were that had the right to the title. Yeah, I guess you could liken it to that.
Yeah, now typically do you do is it like a prejudgment for a writ of, I've never done one myself, is it a prejudgment first and a summons, or can you just file a writ of replevin, do you know?
Well, let's see, I forget, is writ of replevin?
There is a process.
For real estate, or is it just property? I forget.
I do believe it's property. It normally goes through the sheriff's office.
Yeah, but is it for real estate?
Well, it's for goods and chattels in possession of
the defendant. I'm thinking about it. It might not apply to real estate.
I don't know how to the statutes.
One was writ of replevin, and the other one was writ of something else. One was for real estate, and one was for property.
If you do, would you send me an email?
Yeah, and I would do it the trust wise, just like the last person was. I would express the trust and come in through that.
Okay, very good.
I might want to have a colorable, say, a 9-210 statement of account default on or the unclean hands as a colorable way out on a public side of the court to give them a way to save face.
Well, what was the first one? What did you say in 9-1?
9-210, that statement of account that generates the notary dishonor, which is the unclean hands.
See, I've already done that against bunch of people, but we want to make that public. So, and the best thing to do, because a lot of these circuit courts are known to kick papers out or not accept documents, but once we get it, the state's UCC, then it is recognized, and that makes it public, and then I think take it into the county.
Your certificate from the notary, that's outside the hearsay rules. That's the exception. So that should slide in as evidence. And any notary certificate is really an example of the unclean hands doctrine. Because
sure, and
or an act.
And that goes under, there's numerous U.S. Supreme Court case law on that.
Right.
But I'm saying that we file that presentment that, which is basically, it shows a notice of non-certificate and also the certificate of dishonor.
Yeah, but
we get that.
You're crossing it over into the public side and you're giving away your substantive right of the certificate. The certificate comes in through in-chambers and held in private side of the court, but it's just a notice reflecting it in the public side that, hey, I've got this unclean hands doctrine certificate, but it's in chambers.
Okay. So you make a private presentment to the judge.
Yeah, you're bringing them back on the public side of the court, and you're losing them.
Oh, okay. So it has to stay private.
Yes. As soon as you cross it over on the public side, you waive it. Because that opening hands notary certificate is CCI information. It's confidential commercial information, and under discovery, it's trade secret or it's commercial information that needs to be protected. And the only place it can be seen is in chambers. It really comports down to Federal Rule of Evidence 501, which basically says, hey, that the federal rule applies. We use the state, whatever state you're in, the state rules of evidence. So you got to go to the rule of evidence. And in Florida here, my particular one
says
90. 501, which is the general rule, through 90.510. But in particular, I keep pointing these out. It's 90.506, which is privilege with respect to trade secrets, and 90.507, which is waiver of the privilege by voluntary disclosure. What everybody doesn't get is by putting it on the public side of the court, coming through the clerk of the court and register it in there, they are waiving the privilege because they're voluntarily disclosing it. They're making
So at no time should those ever be registered, like with the UCC?
Yeah, you could register them, but then that all goes in chambers. And all I have is a public notice on the clerk side in my motion with an instruction for ordering the court to do an in-chambers hearing.
Right, but that really, once you get in there, then you're getting into detail in regards to the trust. But even on like a finalized presentment, which normally is like maybe 4 pages, it doesn't really get into the body of the previous presentments that you were attacking the other party with. It's just saying, hey, this is completed, but it doesn't really show what you've really gone after, which can be done in chambers. Would that be correct or not?
Yeah, you have to establish that fact in chambers, yeah.
So this way, the body of the dishonor is not there. It's just the notary saying, hey, look, yeah, they messed up. Here's how they messed up. But, you know, all we're saying is this. But yet again, even the judge doesn't know, well, what were the administrative questions that you were asking party B or party A or something like that. But what you haven't disclosed it because you have not sent them typically it would be the 4th presentment, which would be, that's what generates the notice of noncompliance. Now, once the notary gives them the 3 days to cure, then that presents the certificate of dishonor, which is basically like I said, it's about 3-4 pages, but it doesn't get into the body of the complaint or up to the dishonor. You know what I mean?
Yeah, well, that's the specific act of an omission because he didn't respond, and that's a fraud. That's unclean hands.
Well, cool.
And when you're in chambers, that's what you explain to the judge.
Okay. But even the finalized present, that should still be private. That can't be filed into a case.
No, I wouldn't file any of that stuff into the case on the public side. If you file it through the clerk of the court, any of those documentations, you're going to waive them.
Okay.
You voluntarily disclose them.
Yeah, okay.
Get your local court rules and look at that, how that comports down, that 501 rule, how it breaks down. And look and see if you got in your local court rules where it talks about the privilege matter and the waiver of the privilege matter, somewhere in those rules.
Right. Okay, but
take your discovery rules and see whether or not you have a protective order in there and how that protective order talks about trade secret information and commercial information that needs to be held private, or else you waive it by disclosing it.
But don't you want to use that presentment against the party where it does have
in chambers? And all I want to do is put a notice of it on the public side.
So you just lean them in chambers?
Well, the lien should be established already, or the certificate.
And that's how you establish it by, the notary, but doesn't that have to be recorded, such as you have a recorded certificate? Then this way it's recognized.
Yes, but my notices are my UCC1, say, and my UCC or my county recorder certified and then attached to those documents, and all that goes in chambers.
Oh, okay. So basically, you're noticing that the county court, this should be a private document.
Yes, that's a notice.
Okay.
The actual documents never go into the county either. None of these
Okay, now.
crossed over.
All right. Well,
Notices.
all right. Well, let's say it's accidentally filed in there because you file a default. Okay.
Extract it and then put it in the notice of it.
A notice of default.
No. A notice of existence of a private administrative remedy. That's all I got to put in there. As long as I put some kind of specific identifier with it, say a number or something.
Okay, so in other words, just saying that was filed in error.
Right. Say that was filed in error, retract that, and then come in and put a notice in. This is actual constructive notice that a private document exists on a dishonor such and such a number. That's all I got to put.
Okay. Fine.
Pull that out certified. Attach it to your original documents. Put that all in chambers.
Okay, all right, I'll have to retract that then. Okay, yeah, I messed up there.
Because anytime you put actual documents in public, you're waiving your privileged information.
Okay, understand. I was under the impression that because we want it to be recognized in the public, this way you have the force of law when you're leaning the other side.
And the notice are reflecting back to the actual documents held in the private.
Okay, that's a little bit understandable now. Okay, all right, thanks a lot.
Okay, next question, anybody?
Yeah, I have a question. Christian, this is Carlos again.
Carlos, hi, go ahead.
Okay. Now, for those of us that haven't filed UCC1 for claiming and UCC3 for transferring property, is it any different than filing as a creditor debtor UCC1 and 3?
Yeah, the terms don't mean too much difference. I'm going to put on there non-UCC filing.
Okay. So whoever has filed before has to refile again?
No, you might be able to get away with it if you didn't put that on there.
Okay. I haven't filed anything, and I just want to do it right. I've been waiting until we get started, so that's why I haven't filed. And when should I start filing? I mean, any minute now, or should I wait a little longer until we're going to those classes?
Well, we've come up with a lot of different stuff that we're talking about the Declaration of Independence and, the stuff I revealed tonight earlier on the call when we first started.
Right.
We got some major stuff we need to be working on.
I know, but for those of us who haven't filed anything yet, that's what I mean. I don't want to ask anything on that subject. I mean,
I'll get a copy of the Declaration of Independence. Have that on hand. Maybe 2 copies or two of those. Kind of like stand by.
All right. Because some of us haven't filed anything. That's why I'm asking. And I wanted to wait until I find out more about it. I didn't want to file once and then find out I did a mistake and then refile.
Yeah, you're actually better off that way, yeah.
Okay, thank you.
There's really nothing pressing that, I got immediate needs to do on.
Yeah, I know, because, I have time, but I just want to wait until I'm very comfortable, and they said, okay, I'm going to file it once and we're good. Thank you.
You have to realize I'm going slow. I'm going slow for a reason. Because there's a lot of people that are not up to the same speed of learning.
Oh, I understand. And thanks for that, because some of us do need it. There are some guys that are more advanced ladies, and some of us who are really starting, but we also need the opportunity to learn.
Right.
Thank you.
Listen.
Yeah.
I got a question for you. It's concerning a friend of mine in open court. Declared himself to be the beneficiary to the trust and appointed the judge as the trustee. Initially, the judge said he appreciated that. Then when the paperwork came to the judge, along with the formal appointment of fiduciary, the judge got in open court and filed an affidavit saying that he didn't have the capacity, authority, or obligation to, nor wish to have the authority, capacity, and obligation to be fiduciary and a trustee. Okay. Now, interesting enough, a public office is an office of trust, and he, by definition, being a judge, is a fiduciary. Right. Now, since he was appointed that, all of a sudden he said he's not going to be a beneficiary nor a trustee, and he doesn't have a duty nor obligation to put it in writing with an under affidavit, a notarized affidavit. Now the question becomes, isn't that a violation of his office?
Yeah, it probably would be, but you'd have to prove that. But I might want to put him in a rock between a hard spot and tell him, hey, Judge, okay, you got a right to disclose, or disclaim, I mean. And if you refuse, you got that right. But resulting trust is just now formed, and you're under court obligation to appoint a new trustee. And as soon as you appoint him, let me know who he is so I can send him trust res.
Oh, yeah. Well, that was both them and the prosecutor. They both started running like shit, rats off of shit.
Now,
and they're not going to do that. They're not there to
fiduciary duty. Well, then you go right ahead.
Both of them are stupid enough to put it in open court in front of people and say this.
Yeah, you could prove that he was had the duty and the capacity to do it. But you know, under trust law, if he says he doesn't have the capacity, did you ever ask him at that moment, okay, prove that you don't have it?
No, I didn't ask him that. Because basically, the only thing that was put in public was the appointment of fiduciary.
Yeah.
The paperwork was submitted in a closed document. And it's
I think I've been
we deal with all the time, public.
This
28
disclaim. And then I come at him and tell him, hey, you know, a resulting trust has been formed, and it's your duty to appoint a new trustee now, because equity can't allow this trust to fail because you haven't appointed a trustee.
Mm-hmm. Oh.
So now
I've been debating about this, whether I wanted to even go a harder route. I really don't want to, because my take is from what I've been able to understand on the public office law, on the American jurisprudence, that they are all public offices are fiduciaries and trustees.
Yeah, under tax Title 26, 7701. Yeah.
Now, the interesting thing is for him to say he's not, put it in writing in an affidavit, a sworn affidavit, to say he doesn't accept an appointment as a fiduciary, he doesn't have authority, no obligation or duty to endorse or levy instruments against accounts.
Right. Yeah. So, in effect, what you're doing is you're rebutting his statement that he doesn't have the capacity. Now he's got to come back in and prove that he doesn't have capacity.
Okay. And he shouldn't hold that office. My thing is, isn't that an application of your office and your oath of office?
Yeah, you could play that way. Yeah.
Same with the assistant deputy AG. Who said that he's not going to be a fiduciary. If you're holding a fiduciary,
yeah, but it comes down to the point, you know, okay, you don't want to be fiduciary, all right, but you got a court obligation to appoint a trustee, a fiduciary, and that is your duty.
Okay. That's on both sides of that aisle.
Let me know who he is so I can give him trust res property.
Oh, he's got it. $2 million worth of it.
Yeah, but see, here's what happens. If he disclaims, what happens is a resulting trust is formed, and you now become temporary trustee. You didn't know that. So you were holding the title because he disclaimed. Equity says that he's got to appoint a new trustee because this is a resulting trust from that.
Mm-hmm.
Now you have to be given the name and address of this new trustee so you can now give him the trust res. Because technically,
he never sent it back.
Yeah, well, he doesn't really have to.
Okay. So he didn't send the trust res back.
Right. But it reverts back to you, though. You're a temporary trustee sitting there holding it, and you didn't know that.
Now I'll just go back and say you have a fiduciary obligation, you have a duty and obligation to a trustee, and let me know who that person is.
Correct. Right.
And if he doesn't, because I don't think this guy knows what he's doing.
Well, then he would be in breach of fiduciary duty and breach of trust, and also a breach of court under equity.
Mm-hmm. Okay. I think that's a lighter, softer way to go in than the going in like gangbusters like I was initially thinking about doing.
Oh. Yeah. Make sure you tell him the resulting trust is formed by your disclaimer, and now it's your duty, your court-appointed duty, to appoint a new trustee because equity says that a trust will not fail for a lack of a trustee. Now, Judge, should you appoint the trustee, let me know who the trustee, the successor trustee is by name and address so I can present trust res property to him.
Okay, so you're going to read duty. Okay, I'm make sure I got your word right. You said a resulting trust was formed by his disclaimer.
Yes.
Okay. All right. And you have an obligation to appoint another trustee.
Your obligation that way under a resulting trust. He must, according to Court of Equity, appoint a new trustee.
Okay. All right. Thank you.
Okay, one more. Anybody got a question? Last question, anybody?
This is Gary, New York.
Hey, Gary, go ahead.
Can you?
Did you finish your thoughts and your talk on the administrative remedies? Why you stated why you felt we weren't getting them, but did you get a chance to finish that thought out?
Yeah, I did. I just didn't. That's all I had on that topic. Yeah.
Okay. All right. Thank you.
Okay, go ahead, sir.
Yes, this is my first time on the call, so I was wondering if you wouldn't mind offering one or two examples as to how you have implemented this technology either in open court or through dealing with a case, maybe yours or someone that you were assisting.
Yeah, it's not so much whether or not we had success or what we're doing, it's whether or not you believe in what we're doing. But we've had two cases that we put in, and we expressed the trust in one. We just came in with an NOI, and that was sufficient to get the sale on a mortgage foreclosure. The house was going up for sale, and it got pulled off the sale block about 2 hours before the sale. But then they rescheduled the sale later on in 45 days, put it up for sale again, and that went through. In another case, we came in and we went in with the second step. We went in with the NOI, same way we did on the first case. And the second time, we went and came in with the SOI now, which is the material facts to prove that NOI, which was the claim for the trust. And that case then got, they closed down.
Okay.
So those two instances, we believe that, we're expanding on them from where we've taken them so far. And we need to fine-tune them some more, add more things to it, and go from there. But since we've discovered this whole NTT as new trust technology, which is really a quantum leap in everything that we've been doing since the past, because everything we've been doing is under debtor-creditor. So this is a new direction. A lot of it is brand new. It's all groundbreaking. We're doing it as we go along, so to speak. And it boils down to that, you need to study trust law, and I'm sure if you get in there and start seeing some of the things we see, you'll be along with us.
Okay. Appreciate that.
So if you want to send me an email at movingtitles@hushmail.com and request some of the past audios, I'll send you a list of audio downlinks.
Yeah, I've done that already. I sent you an email earlier tonight.
All right.
Appreciate it.
Okay. We get about maybe 6 minutes, maybe one more, huh? Anybody else have a question? Nobody else?
This is Beryl.
Carol, how are you? Go ahead.
I'm good. How are you? You had talked in the beginning about, the debt from the war, and I'm wondering what your thoughts are as far as settling that debt.
Could you expand on that a little more?
Well, part of the problem that we're facing is because, the debt from the revolution and actually from the settlement of America was not paid to England. And so how are you thinking that debt is going to get settled?
Okay, that's really not a whole big problem because, I am a bank and I have access to all the credit. I'm the sole source of the credit. So if we need ever amount of money, I can issue it.
Okay, so that sounds like a simple solution, but a complex path to get there.
A simple model, yes. Some of the details as to like who is holding the account, who's the specific party involved, yeah, there's a little more details that need to be probably worked out.
Mm-hmm. Do you have any, ideas on how we're going to get that done?
Well, as I said earlier, the IRS is the individual master file holder, and he's got the commissioners in charge of that, so he's the entity that's going to be the one I'm going to get the master agreement with. That's going to be effectively disconnecting me from the whole thing after I've made the request for the payment of the debt and put in the correct forms, as we've been discussing on a call.
Okay. All right, and all that's going to be covered in your workshop?
Yeah, we're going to be working away at it. That's the workshop, yeah.
Okay, well, I look forward to that. And I shall say good night.
Hey, Chris, when is these workshops going to be?
In January.
Letterhead, middle of what?
Probably about when I announced the announcement there, probably about 2-3 weeks.
Okay, something like the middle of January.
Out there, I have a need for an email program that I can do bulk mailing. Because last night my email program closed me down because I was sending out too many emails in 24-hour time. So I'm working on like 13 emails at a time. Now I understand there's some other programs out there, like maybe I've heard Hotmail that allows you to do 50, but I need some program that will allow me to send out like 100, 500, 1,000 of them at a time without fooling around. Does anybody out there know of a program that could do that?
That's more of an issue with your ISP, because you're going to get flagged as a spammer if they see that many emails coming out at one time.
Okay, so I might have to check with them then.
I would check with them.
And a good way to do that. Get your own domain.
Yeah, if you have your own domain name, then then you can get away with it that way.
Well, you can get your own domain. It's like $10, and then go get a program, email client called the BAT, and you can send out thousands.
Okay, what's the program again?
Called the BAT.
Can you spell that?
THEBAT.
Okay.
That's an email client that rests on your computer. So instead of doing email online, you're doing it from your computer direct. You go to one of the internet registry domains and you get your own domain, ChristianWalters.com or whatever you want. And from that domain, you can send all the emails you want right off your computer.
Great.
You still have to go through a process to make sure that you don't get blacklisted.
Yeah, if you get too carried away, you'll still get marked by Yahoo and stuff like that. But you can send out quite a few without a problem.
Are they looking for, somebody that does a lot of emailing all the time? Is that how they do it? or do they go on complaint?
No, it's a combination of the two. They look if you are not specifically on the list that identifies you as a high volume email user or someone that will send out thousands of emails that's in a 24-hour period, then you're going to get blacklisted.
Okay.
So you have to go through the process of speaking to someone, and then more than likely the person that holds your domain will be able to assist you with that.
All right, thank you.
I was going to say you might want to try, they have one called MailChimp.com. That's a subscription service, and I think you can do up to about 500, and I think it's a paid service for over 3,000 or something like that per month.
Mm-hmm.
That one's called again, what?
It's called MailChimp.com.
Is that M-A-L-E or M-A-I-L?
It's MailChimp.com.
Got it. Okay, well.
And Chris, your email was moving titles at hush.com?
Yeah, hushmail.com.
Hushmail.com. Okay. Thank you.
Okay, well, I'll see you tomorrow night on the talk show at 8 Eastern Time. If anybody wants that number, that one is 724-444-7444, and the PIN access number is 41875. That's at 8 Eastern Time.
Kristen,
Yeah.
that's going to be canceled.
Oh, they got to cancel?
Yeah,
Okay.
tomorrow.
I get a rest tomorrow?
Yeah, you get a rest tomorrow.
Hey, okay. All right.
Christian, if you need a hand setting up a domain, maybe where you can host things along with these recordings and do that email from, I'd be willing to help you.
Well, send me some information.
Okay.
Who's this again?
This is Eric in Florida.
All right. All right,
I'll
so
send
I'll
you
get on a Saturday call then next. Everybody has that number?
No.
Okay, that number Saturday call is 712-432-8773, and the PIN number is 179441#. And you could get that off the internet if you want to listen. Just listen. It's therealpublicradio.net. therealpublicradio.net. If you want to call in and ask questions, the number again is 712-432-8773, and the PIN number is 179441. So I'll see you all on Saturday. All have a Merry Christmas. Write down your questions. Get out Gilbert's Law book.
Merry Christmas, Christian, and thank you.
Okay.